in January. So today what we're going to try to do is 6 cases. So we're going to spend 8 or 10 minutes per case. Of course, if we get stuck on a case because it's something that you guys are interested in, then of course we'll stick with that case and we'll blow the other cases off. But we're going to try and get through all 6 of these cases. Elizabeth Capoletti is here with me today, and of course we're going to kind of reprise our good cop, bad cop routine that we sometimes do here. Of course, she's a good cop. And also, we're lucky enough to have some of the lawyers who actually handle these cases with us today. So we're going to ask those lawyers to make some comments on the cases too. So that's the plan for the program today. All right, any questions about that? All right, then, here we go. So the first case that we want to talk about is the PPG Industries case. This is a repetitive trauma case, and it's important to understand what evidence can be submitted when you're trying to prove a repetitive trauma case. So the quick facts of this case is that this woman, Carrie Bond, worked for PPG Industries, essentially as a laborer, although she did she did various jobs during the course of her employment there. She worked there for 38 years. She alleged a repetitive trauma shoulder injury. In this particular case, the arbitrator awarded benefits, and the commission affirmed that award of benefits. The circuit court reversed the award of benefits, and the appellate court reinstated the award of benefits. So the issue in this case was the statute of limitations. So when Ms. Bond testified about her work at PPG Industries, she testified about all 38 years worth of her work at PPG Industries. She went back 38 years and told the arbitrator everything that she had done working for this employer for the last 38 years. The respondent's contention about that, the respondent's issue with that, was that the respondent argued that that particular way of presenting evidence might be in violation of the statute of limitations, right? Because if the statute of limitations is 3 years from the date of the injury, why is Ms. Bond being able to testify about things that happened 38 years ago? So the respondent's contention was that there was somehow a violation of the statute of limitations when Ms. Bond testified about information that about her job 38 years before the time of the hearing. So the arbitrator denied the respondent's contention that somehow that testimony was barred by the statute of limitations, and again, the case went all the way up to the circuit court. The circuit court reversed that finding that the statute of limitations had in fact been violated by the petitioner being able to testify about work that she had done 38 years prior to her date of injury. So the question becomes, when the circuit court says reversed and remanded back to the commission, the question becomes, how does this case get to the appellate court? Why doesn't it go back down to the commission first? And you can see what happened in this case. If you look at the decision, is that the petitioner's lawyer invoked Supreme Court Rule 308 in this case, and asked the circuit court to certify a question to the appellate court so that case could be taken to the appellate court first as opposed to coming back down to the commission. So on page 4 of the decision, you're going to see the reference to the question that was certified to the appellate court, and it says, Section 60 of the Act, which sets forth a 3-year statute of limitations for the filing of a workers' compensation claim, act as a bar to the presentation of evidence of work activities that took place more than 3 years prior to the date of accident or manifestation date of a repetitive trauma injury. So that was the question that was certified to the appellate court, and basically the appellate court answered that question, no, it does not. It does not, the statute of limitations does not act as a bar. Now, the appellate court didn't say that that evidence was somehow automatically admissible. Of course, what the appellate court said is that the evidence had to be relevant. It had to have something to do with her repetitive trauma injuries. It had to meet all those other standards that all other admissible evidence meets, but those are evidentiary questions as opposed to the statute of limitations questions, and those are evidence questions that the commission, of course, in its discretion, is able to determine. So that's the issue in this case. Any comments, Elizabeth?
No, that's what, I mean, they basically just said that it's strict statutory construction, and they didn't really look at the evidentiary issues, because those weren't really before the court. It was just whether or not the statute of limitations would preclude that type of evidence.
And of course, as always, what we've tried to give you in the written materials is a copy of the appellate court decision and also a copy of the commission decision where we were able to find it, and that way you can see what the commission did and compare it to what the appellate court did. So the next case we want to talk about is the Ferris case. Is Matt Bailey here? Matt? I asked Matt if he was going to be here. He wasn't sure. He was the respondent's lawyer in the case. So the Danny Ferris case is a very complicated procedural history case. Okay, so just really quickly, let me see if I can give you the history here. So it's an accident dispute. First of all, the respondent alleges that this accident never happened. In fact, brought in some witnesses to allege that the accident didn't happen. It wasn't a causal connection argument. It wasn't, his injury isn't as bad as the petitioner says in his argument. It's this accident never happened. In fact, the testimony from a co-worker was that the petitioner told the co-worker prior to having this accident that he was going to fake an accident work because he had a balloon mortgage payment that he needed to pay and he needed the money from the, anyway, that's what the testimony was. So, in this case, on the basis of hearing that kind of testimony, the arbitrator denied benefits based on accident. The commission at first affirmed and adopted the arbitrator's denial of benefits, but in this case, the circuit court once again reversed. The commission decision found that instead of using the evidence of this witness as impeachment purposes, they used it, the commission used that evidence as substantive evidence, and the circuit court thought that that was error. Also, there was an issue about the petitioner wanting to reopen proofs in the case, and the arbitrator denied that, and the circuit court found that that was error, and so remanded the case back to the commission. Again, this is a case where it was remanded to the commission, and it seems like, there are always issues with these cases that somehow get remanded to the commission, whether they're appealable in the first place, what happens when they come back down. So here's another case where it was remanded to the commission. Take a look at the remand order that is in the appellate court decision in this case, because there's a really interesting decision. There's a really interesting footnote in the appellate court decision that I think we need to stop and take a look at. I mean, it's a footnote, so you might say, why are we dealing with a trivial footnote? But it's a really important footnote that I think you want to take a look at and compare to the remand order that you see in the appellate court. So the footnote in the appellate court decision says that the employer could have challenged that first remand order to the commission as an appealable order, okay? So the question is, if you could have done it, should you have done it, all right? And so there are some interesting issues regarding waiver and some interesting issues regarding, what does it mean when a case is remanded, all right? So the case gets remanded back to the commission. The commission vacates the arbitrator's vacates its own denial of benefits and remands the case to the arbitrator for another decision. The arbitrator once again denied benefits in the case, but this time the commission reversed and awarded benefits in the case. So the commission looked at some medical evidence that was introduced and said that that medical evidence seemed to be supportive of the petitioner's version of the events about how the accident happened. Don't forget the employer was denying this case based on accident. So, again, it gets back to the circuit court now with the commission having found in favor of the petitioner and awarded benefits, and the circuit court reverses and says that no benefits should have been awarded in the case. And that's the decision that finally gets appealed to the appellate court. And what the appellate court says is that the commission's decision awarding benefits, the second commission decision awarding benefits, was not contrary to the manifest weight of the evidence, okay? There's some really instructive language in this appellate court decision about what it is that the appellate court is actually reviewing, especially on these cases that get remanded back down to the commission and then come all the way back up to the appellate court, okay? So first of all, the appellate court tells us that, number one, what the appellate court looks at is the commission's decision, okay? The appellate court doesn't really care about the circuit court decision. It's the commission decision that's being reviewed. And as far as I can tell here, at least from this decision, it's that second commission decision that's being reviewed. That first commission decision that was reversed by the circuit court the first time around is not being reviewed in any way by the appellate court. There are some issues in this appellate court case about what the record should contain. There, apparently the testimony of the witnesses didn't quite, which was done at that first arbitration hearing, didn't make it into the record on appeal as it went back up. So there are some issues that the appellate court is saying that they're kind of handcuffed because they can't review the testimony of those witnesses because it's not necessarily part of the record here. So the practice here, be careful about what your record contains as you go up the ladder to the circuit court and to the appellate court. If you think your record should contain something that it doesn't seem to contain, you should make the appropriate motions to supplement the record or to add on to the record or whatever that appropriate motion might be. Okay, Elizabeth, any questions about this?
Yeah, no, I mean, this case is really a lot of practice tips. I mean, generally in the appellate court, if the appropriate record is not filed by the appellate, it's construed against the appellate. It's their job to file the record. In this case, though, the court really looked at the fact that it was the employer that filed the original record at the circuit court where it wasn't complete. And they didn't invoke what they generally invoke, holding it against the appellant, because they thought that the employer at the circuit court had the duty to actually file the appropriate record. The other issue is you can always supplement the record at the appellate court by stipulation. You can, come together and say, hey, these should all be here. Let's stipulate and put it into the record. Depending on how far you are on in the process you are at the appellate court, you can also make a motion at the circuit court if you can't have that stipulation and have it heard at the circuit court, which then can grant the order, and then you have the documents, bait stamps, and then refiled in the appellate court. So I think that was a big problem, is that the appellate court felt that the circuit court had no basis on which to make this finding that it was against the manifest weight of the evidence, because there was no record from that real first hearing in 2005. And that's also another good thing you should remember. When you take these matters up to the circuit court and they get remanded down, you take them up again and you have a new L number. And a lot of times the record is with the first L number. You have to be very aware of that when you make a request for the record, because a lot of times you won't get all of the information that's actually under that first case that you've appealed to the circuit court. You have to supplement the record, or you can do a motion to consolidate all the cases for purposes of filing a record before the appellate court. So I think that that was a very good tip from the appellate court to tell you must always look to see if your record is. And as to the second one, I mean, they clearly didn't review the original commission decision, but the case law is pretty clear that should be the decision that's generally reviewed first. I mean, if it's reversed and remanded on a factual question, then you always look to the first decision. It appears here in this case they didn't do that because no one brought it up to them. No one said, hey, we need you to look at that first decision. So again, as a practice tip, if you're up on appeal, bring up every issue should be brought to the appellate court, even sometimes if you want, because you're waiving some of those issues if you don't bring it up. generally under the law, they usually just go and look to the first decision. So this is a little bit strange that they chose not to, because if you look at most cases, they automatically go back and always look at the first decision.
You know, and the commission's decision after that first remand was it vacated the original decision. So, you know, whether that is stepping beyond the authority of the remand, you know, those are all issues that we have to deal with when you're looking at these cases that are remanded back to the commission. So be careful about those remands. There's a lot of pitfalls that you could fall into, you know, on those remands. Two other real quick issues about how you perfect a review in circuit court. In this particular case, the respondent had left the commission off of the caption of one of the documents, had left the Workers' Compensation Commission off of the caption one of the documents, and the appellate court said that was not a fatal error. That we just the kind of Scrivener's error of leaving the commission out of the caption wasn't fatal to perfecting the review. But there's a more important issue here about where you file these reviews, right? What the Act says is that the circuit court review can be filed in any county in which any party defendant can be found. Okay, can be found. In this case, the case was filed in Rock Island County. The judge found that was not the proper venue for the case. But the petitioner made an additional argument. The petitioner said, well, if it's not the proper venue, then that circuit court review was improperly filed, and the circuit court has no jurisdiction. So what the petitioner said was the filing in the wrong venue divested jurisdiction from the circuit court, and the appellate court in this case says no, that's not the case. It's a venue issue as opposed to a jurisdiction issue. So the review was properly filed, even though it was filed in the wrong county, and it was transferred to the correct county for the review. All right. So yes.
I'm troubled by the fact that the court didn't review the first decision that I think to have to time a little more. Either I or my opposing counsel have tried to file a notice of appeal for a circuit court decision remanding the case to the commission. And each and every time the appeal gets dismissed, the appellate court holds that it's an interlocutory appeal because the case has been remanded to the commission for further proceedings. So what really troubles me is that the court says in that footnote that by not appealing the circuit court's remand order, the court raised two issues on the note. When we've been told time and time again, you can't appeal those remand orders.
Yes, that's why I brought up the footnote. It scared the, you know what, when I read it, right? Because sometimes we fall into that kind of trance where it says remand, and we're like, okay, remand, I'm going down. Well, maybe you're not always going down when you get a remand order. Maybe you're actually going up, and maybe you should be going up instead. So, Mark, I wish I had a better answer than that. I don't. I mean, it's just.
Mark, the way I interpreted it was that it wasn't that they were supposed to appeal it in the first instance, that it was supposed to go back down. The way I read it in that footnote was it should have been brought up by someone when they brought it up before them the second time. And it appeared that no one brought up the fact that we should be looking at that original decision. Therefore, the court didn't feel that they should do it on their own.
You're saying brought up the issue.
Right, brought up the issue.
Bring it up on it.
Correct, I'm sorry, yeah, exactly. I mean, I didn't read that footnote to say, hey, someone should have appealed it that first time when they reversed and remanded. I read it as someone should have brought this issue up. Now that we're up here now, someone should say, hey, we should be looking at the original decision. And that's why I said, that's a big contrary to if you look at all the case law, because all the case law seems to indicate that they just automatically do that. If you look at, I think FED manufacturing is the case where they talk about it, where if it's reversed on a factual matter and remanded to the commission, that we automatically go back to the first decision. So it's a little strange the way they went about it here. It does.
Well, here's my solution to this problem. Take your notice of appeal, let your opponent file a motion to dismiss, and the appellate court will either dismiss it or not dismiss it, but, you have the possibility of guessing wrong.
And I've also done where you file a notice of appeal and then I file a motion to clarify jurisdiction. So I file a motion asking the court if they have jurisdiction.
And in fact, you know, at the appellate court lunch, on, Black Wednesday, what I like to call Black Wednesday back last November, but on the appellate court lunch, one of the justices actually mentioned that type of, procedure, this idea of filing notice of appeal and then filing a motion to clarify jurisdiction. All right, any other questions about this one? All right, so, yes? No?
Okay, we just have to finish with now. You know that they have to do it in this appeal, so what they're going to say.
Well, if it was appealable, if it's appealable now, okay, why wasn't it appealable then? That's the question that I have, What makes it appealable a year later, 2 years later, when it wasn't, if it wasn't appealable within that first, 30 days? So that's the part that I get a little nervous about. So, you bet your life if I make the mistake, I'm going to cite that footnote right back to them, ever again. But just be aware that it's an issue, and Mark probably got the best solution, What does it hurt to file a notice of appeal, right? All right? Anything else? Okay, good. So Amron is a occupational disease case. We don't see very many of those, so that's why it's a really interesting case. So in Amron, we have a situation where the petitioner traveled to Brazil as part of his job, and he claimed that, or his widow actually claimed that as a result of traveling to Brazil, he caught a particular kind of meningitis. Being exposed to it in Brazil. In this particular case, the arbitrator found that it was not a compensable incident, that the petitioner failed, the petitioner widow, because ultimately Mr. Bauer died of the disease. The petitioner widow did not prove her case, but the commission reversed and found that he did. Essentially, you can look at the commission decision. It's a nice, long decision that analyzes some of the requirements of the Occupational Disease Act, but essentially, this case came down to a battle with the experts. The petitioner's experts testified that the decedent was exposed to a greater risk of catching this disease in Brazil. There were statistics about how prevalent the disease is in Brazil, and the commission decided to go with the petitioner's experts. So as the case goes up, the circuit court confirms the award of benefits, and the circuit court, the appellate court also affirms the award of benefits. There's an interesting paragraph in the decision, in the appellate court decision, that I think bears at least reading once. So I'm going to do that now. It's on page 9 of the appellate court decision, and it's citing from section 1D of the Occupational Disease Act, and it says, "The disease shall be deemed to arise out of the employment if there is apparent to the rational mind, upon consideration of all circumstances, a causal connection between the condition under which the work is performed and the occupational disease. The disease need not to have been foreseen or expected, but after its contraction, it must appear," again, to that rational mind, right? "To have had its origin or aggravation in a risk connected with the employment, and to have flowed from that source as a rational consequence." So that's what the Act itself says. and that's the standard of proof that the commission and the appellate court applied to this case. Nothing in the statutory language requires proof of a direct causal connection. So that was the respondent's argument in this case. The respondent's argument in this case was that the decedent or widow, they couldn't prove that Mr. Bauer had come into direct contact with meningitis anywhere, and that was, according to the respondent, fatal to the case, but not according to the commission or to the appellate court. So this is a really, really good primer on how we go about proving an occupational disease case, what the standard of proof is an occupational disease case, and a really good reiteration of what the statutory standard of proof is in the occupational disease act. All right, any questions about this one? Yes.
Dave, I like what you were reading, but I wish you read that additional sentence where they say that causal connection may be based on a medical expert's opinion that an accident could have or might have caused the injury.
Okay, so that's a good suggestion, Tom. I'll read that sentence. A causal connection may be based on a medical expert's opinion that an accident could have or might have caused an injury. So, especially with the Occupational Disease Act, where you're dealing with that, rational mind kind of idea, rational consequence kind of idea, I think that's an especially important sentence, although it does not seem to be limited to Occupational Disease Act cases, at least if you remove that sentence from the context of this Occupational Disease Act case. Well, let's read the next sentence, too. It's a pretty good sentence. In addition, a chain of events suggesting the causal connection may suffice to prove causation, even if the etiology of the disease is unknown. Okay? So, in this case, it was a pretty well-documented chain of events to help this widow prove her occupational disease case. All right, any other?
Yeah, I think it just basically came down, they knew the etiology of the disease. The question really was it speculation to say that he got it while he was in Brazil? And he had two experts to say, no, we think based upon everything here, we can infer the fact that he was exposed to this disease in Brazil. And the respondent had two experts that said, no, that's all speculation, the math doesn't add up, and the commission weighed both experts and agreed with the claimant's expert. So, it just came down to, weight of the evidence for the commission.
Yes, Mark.
I recall the surgical nurse case. I think that was your office's case. How's this?
Thanks, Mark.
I just recall it. Maybe it was Chuck's.
Well,
Can somebody tell me?
is Chuck here? Chuck, come on. Little help.
All I know is that it seems to me that the surgical nurse, we know for sure that the surgical nurse is exposed to AIDS and hepatitis C, etc. Even though this is this is an unusual disease, and we're inferring that he was perhaps exposed to it in Brazil, but there is no direct evidence. I understand the quote to you in the third sentence here, but the surgical nurse lost, and maybe I don't have a rational mind, but to me, rationally, she got her hepatitis C from being a surgical nurse.
So the case, yeah, so Chuck is here, and the case that you're referring to is actually cited after that first sentence. It's called Spurley. So yeah, that's the Spurley case, and Chuck says that you only have to say two words to explain that unfavorable decision, and those words are Jim Sansone, right, Chuck? Is that the
Correct.
Is everybody?
There's about 8 people here who know what I'm talking about.
Well, maybe more than 8. So.
Fundamentally, it's statistical evidence.
So
In the case of the nurse, in the case
maybe the way to reconcile these cases is that as they go up, of course, they all go up as manifest weight cases, right? So Spurling ultimately is a manifest weight case, just like Amron is, okay? So it's a manifest weight issue. Now, we argue that the wrong standard of proof was used in Spurling, but the Supreme Court didn't necessarily agree with that argument. So, in fact, didn't agree at all with that.
No, they didn't. It just seems to me that I didn't think upon that as necessarily as a manifest weight case. I'll reread Spurling, but it seemed to me that the court there basically told us you can't use
clearly marked, read Spurling, please. It's clearly in the Supreme Court, Spurling is a manifest way case. In the Supreme Court, clearly it's a manifest way case.
Okay, the commission, Mr. Sansone and the commission placed weight in Spurling on the fact that each time that she had a needle prick as a surgical nurse, she didn't stop at file an accident. So it was a manifest way case.
So
Sansone denied the case. The commission, as I recall, in a split decision, it was back when we just had all five in those days. In a split decision, affirmed Sansone. Circuit court confirmed. The appellate court reversed. And I want to say a 4-1 decision, might have been 3-2. The decision was written by Calvo. Subsequently, by the time we got to the Supreme Court, Calvo was on the Supreme Court. So he obviously took no part of the decision. And it was written by Justice Ryan from DeSalle, Peru. Basically, it was not against this one.
And the Spurling case, just so you all understand, it's a very common thing, a nurse with a needle prick, right? She ends up with hepatitis C, right? But she can't identify which particular needle prick, might have given her the hepatitis C. She excludes all the other risk factors for that, disease. Has experts testify that nurses are at increased risk of hepatitis C when they get pinpricks at hospitals, but it apparently wasn't enough for arbitrators and so.
At the lower levels, the commission was talking about we didn't have the direct proof. And their factual thing was that the direct proof would have been if she'd been reporting these needles. In other words, they were disputing that she would have needle sticks that were unreported.
So this is a clarification that you don't need that direct proof, right? You can prove it statistically or through probabilities, I suppose is a better way to put it.
Because we don't know who gave Bob the same thing with the nurse, we don't know.
I think this was what's the right word? You could arrest her, right? I mean, I think this was something you could actually inhale. You didn't have to come into contact with someone, right? I think this, if I'm not mistaken, if I'm remembering the facts.
Right, and I think there might, although they don't talk about it here, there might a bit of distinction maybe, because clearly a traveling employee, right? So you're looking at reasonable, foreseeable, as opposed to our, normal standard for a discrete injury. So that's usually, is it reasonable, foreseeable that you're going to come into contact with this type of disease when you're traveling? Yes.
I was kind of surprised that they didn't read it.
So, moving on, unless there are any other questions about this, okay, good. So moving on to the company case. So this is a case where the petitioner filed 3 different cases for separate and discrete accidents against the Levy Company. One of the cases seems to have been filed against Walsh Construction, but it's my understanding that actually that case was part of their wraparound policy. So actually, the petitioner was working for the Levy Company, even though Walsh was the respondent in that case. So the petitioner actually tries one of his cases on a 19B, and it's found that his condition is related to the injury, and he's awarded a prospective surgery based on that 19B. After that 19B is tried, the petitioner settles the first 2 cases. Those cases had previously been consolidated before the arbitrator to that last case. In order to settle those first 2 cases and leave the 3rd case pending, it's my understanding that the petitioner made a motion to sever the cases before the arbitrator. The arbitrator denied the motion to sever the cases. The petitioner presented the 2 settlement contracts on the first 2 cases to the arbitrator. The arbitrator rejected the approval of the two settlement contracts because the arbitrator said, I haven't severed the cases. You know, they've all got to be done at once. You can't do them piecemeal like this. The arbitrator rejected the settlement. Under the rules, the rejection of those settlement contracts was then brought to a commissioner. The commissioner approved the two settlement contracts on the first two cases and left the third case pending. So that's the kind of factual summary of the case. The circuit court, when the respondent reviewed approval of the settlement contracts to the circuit court entered an order which confirmed the commission's jurisdiction to settle to approve the settlement of the first two cases without doing anything with that third case leaving it pending. It denied the employer's motion to set aside those two settlement contracts. It noted that the third case, the last case, was still pending before the commission, and once again, it remanded the case to the commission for further proceedings, I guess, on that last case, and then the employer filed the appeal. So when it gets to the appellate court, the employer argues that the commission was without jurisdiction to approve the settlement of those first two cases because the arbitrator had previously denied the employee's, the petitioner's motion to sever the cases, and the appellate court said that that argument was without merit. So it said no, the commission has the discretion to approve some cases and leave some other cases pending. The employer also argued that the commission erred without hearing testimony or gathering evidence about why those first two cases were settled and the other case was left pending. And once again, the appellate court said that there's no legal support for that argument. So that Levy case is a case that may be in contradiction to a couple of other cases that we talked about maybe 2 or 3 years ago. There's a case called City of Chicago and a case called Baumgartner, right? And remember what these cases stand for? It stands for this idea that, you know, if there are multiple pending cases, what you're looking at is the petitioner's, you know, final condition to determine what that award should be. So the cases kind of all get blended together, and you can't really do this thing where you resolve one case and then, you know, come back and resolve another case separately. So this case seems to have a different kind of holding than we saw in those cases, City of Chicago and Baumgartner. Everybody remembers those cases? All right.
Yeah, I have a little bit different. This case, I took it over right before the oral argument, and really what the justices were concerned about was the fact that it was the same respondent. It was in all 3 instances was the same respondent. So how do you, being respondent number 3, make an argument different than that of respondent number 1 when you are all the same respondent? I mean, they appreciated the fact it was different insurance periods, but they were troubled by the fact it was the exact same employer in all 3 circumstances. Also, the first 2 injuries involved the shoulder claim. They're distinct and separate injuries relative to the shoulder, and the third injury was a low back claim. So they were different parts of the person. And I think there's the most recent case that just came down talking about how you can't make the argument because it's shoulder and back, but they're all the same because it's man as a whole. Really, I think Baumgartner and the City of Chicago talked about if you've injured your knee in all 3 of these cases, then we have to look at it together because we're looking at the same body part. That doesn't necessarily apply when you're just talking about person as a whole, and you're talking about back, neck, shoulder. So, but in this case, it was really specific to the fact it was all the same employer. So I'm not sure it would be the same holding if you had 2 separate employers. Their concern was really because it was one employer. They were all different
Any questions about this one? Lead company? Okay, good. Bob Red Remodeling is the name of the case, I'm sorry, so it should say Bob Red Remodeling on the slides instead of Rob Red Remodeling. Matt Belcher had the petitioner in this case, so I'm going to ask Matt to come up and present the petitioner side of the equation.
We're running kind of late on time, so I'm going to go as fast as possible. First, I want to say thanks to Dave. I don't think we appreciate enough how much his efforts here help us in the practice, so thanks very much. So by way of background information, Mr. Lamonti comes here from Poland. He came in 2003, doesn't speak English. He's got a vocational background of doing automotive repair and working as a shopkeeper. In 2007, he finds himself doing construction work. July 28th, 2007, he's 55 years old, he doesn't speak English, he's on top of the roof. OSHA requires, as we all know, fall protection for different industries. For general industry, it has to be at 4 feet. Fall protection is 5 feet in ship yards, 6 feet in construction, and 8 feet in longshoring. So, who wants to guess that the employer was in compliance with OSHA regulations in this case? The answer is no. So, OSHA regulations 1926.501 B1, each employee on a walking service with an unprotected side or edge, which is 6 feet or more above a lower level, shall be protected from falling by use of a guardrail system, safety net, or personal fall arrest system. Mr. Lamonti did 11 feet, no fall protection, no tow board, no harness, no safety line, no net, no guardrail, no personal fall arrest system. So head first off to the roof. There's a dispute, lack of consensus among his coworkers as to whether or not the single came loose, whether somebody bumped him, or whether he just went off head first. Regardless, Mrs. Lamonti gets a telephone call. By the time she gets there, the only thing she finds is his hat and a big pool of blood. The ambulance took him to Masonic. At Masonic, he's examined by Dr. Transler. Dr. Transler keeps him under observation, and a week later decides to do surgery. One of the arguments in the case is that Mr. Lamonti, there in intensive care, laying there under observation, since he was there for a week, he chose Dr. Transler, and that was his first position. As we'll see, the arbitrator commission in South Court disagreed. So, one interesting note is that Mr. Lamonti was continued to be seen by Dr. Transler for 4 months. The appellate court says that from now on, any ordinary treatment and normal follow-up subsequent to surgery or customary emergency services, that's not a choice of position. So he went there for 4 months. It wasn't just a week. So he practiced it. The client goes to see a surgeon, sees an emergency room physician. Any follow-up that's ordinary, considered to be normal follow-up, it's not a choice of position. Regardless, after the craniotomy, he wound up having physical therapy, speech therapy, as well as some follow-up treatment. The case goes on for a few years, continues to be paid benefits. There's a Section 12 examination of Dr. Zolman. Dr. Zolman is the director of brain injuries at the Chicago Rehabilitation Institute, so clearly she's the dean, so she can do everything she says. She has a plan of treatment for Mr. Lamonti. Mr. Lamonti does not comply. Mr. Lamonti is getting treatment from his primary care physician. He's an internist. The internist thinks that he's doing a good job for Mr. Lamonti. Dr. Zolan, the director of the traumatic brain injuries at the Rehabilitation Institute of Chicago, says no. He disagrees. The respondent filed a motion to terminate benefits for injurious practice. We take the deposition of Dr. Zolman. I asked Dr. Zolman if she's aware that, you walk into the RIC, I don't know if you've ever been to the traumatic brain injuries, and if you walk in, there's a big sign. Our mission statement is to help people with traumatic brain injuries. They call them the victims of traumatic brain injuries. So about halfway down, I asked her, you're aware that your testimony is being used today in exchange for $10,000 to cut off benefits or deny benefits to a person with traumatic brain injury? And I answered that question. I said, no, you have to answer that question. Please answer. I'm going to call my lawyer. So we sat there for a half hour where the lawyer came. So, then I asked her again, and she wouldn't answer the question. So we moved on, and then I asked her another question, saying, well, you don't speak Polish. You have no idea what this gentleman's saying. You're relying on the translator. He refused to answer the question. They got up, they walked out. All right, whatever. So they filed a petition to terminate benefits. They also filed a 137 motion for sanctions and a 206E, Supreme Court Rule 206E motion to assess the cost of the deposition because I would address it. The arbitrator, here is a spoiler alert, the arbitrator said that while I was aggressive, the doctor was evasive. So the 206E motion was denied and 137 sanctions was denied. We take the deposition of the internist. The internist says, well, I have occupational experience and I've concluded that the person has lost access to any meaningful employment. Therefore, he's permanently disabled. During the deposition of the doctor, the treating physician, of the Section 12 examiner, another reason to take the deposition called Section 12 examiner, I asked her, well, when it says here that Mr. Lemansky can go back to work, what does that mean? What kind of job? She says, well, you know, we work with these vocational providers, and they have supported work environments. What's a supported work environment? Needless to say, we never really fully got into that. I did ask her if you're aware of any vocational market in Chicago, and they didn't want to answer that. And I asked if she had any vocational training, and she said no. So we had to have a trial. So we had the trial, and the first witness called is a staff member from my office, so she can lay the foundation for a day in a life video. Okay? So we do a day in a life video to show how Mr. Lemansky is, you know, now he's 57 or 58 years old, and how his life is different than when he was 55 and working on roofs. Second witness was Lisa Helma from Joe Belmonte's office. She came to testify about the vocational assessment of Mr. Lemansky. Ms. Copley made a 48-hour rule violation objection, saying that I failed to comply with GEAR by not providing her with the vote rehab report prior to the trial. That was overruled because Lisa Helma is not an MD. 48-hour rule only applies to medical doctors. Ms. Helma testified that, in fact, he's an odd lot because of his age, training, disability, lack of cognitive skills, that he's lost access to an identifiable occupation in the state labor market. Subsequently, the arbitrator concluded that he was an adjudicated perm total on either theory. So first, he was medical perm total because he found that the internist was more credible than the director of the Rehabilitation Institute of Chicago's brain clinic, because the doctor at the brain center doesn't speak the language of workers' comp. When we asked her, why do you think that he's not permanently total, she said, well, you know, a person is permanently total, but they need to have a feeding tube, they're basically in a vegetative state. So when you ask an interrogatory practice, if you ask an interrogatory doctor, you might want to ask them the basis for their opinion, so you don't wind up in a deposition finding out that when she said he could go back to work, she meant in a sheltered work environment, and then when she said that he wasn't permanently totally disabled, she meant he wasn't in a vegetative state. Regardless, the arbitrator concludes that the internist is more credible. We award CTD through a date certain, and then award term total benefits and denied the 137 motion for sanctions and the 206E motion for assessment of costs, and then the case goes to the commission. We received that decision in March of 2011. As soon as we received the decision, it was basically denied the motion to terminate benefits for injurious practice, granted my request of hearing, saying that in fact he is permanently totally disabled. Of course, they stopped paying them. So for 191 weeks, Mr. Lemansky, a person that they alleged had such a serious brain injury that they needed to care and treatment of RIC, wasn't paid any benefits. So we go to the commission affirms on all issues except strikes reference to an FCE. The arbitrator made reference to an FCE that was not part of the record. That FCE had returned Mr. Lemansky to a below sedentary job. So we go to the appellate court. The appellate court basically, you could read it yourself, basically affirms the arbitrator's commission. So here's a few practice tips that an internist who is more familiar with workers' compensation can be more credible than a highly decorated clinical director who is less familiar with workers' compensation. If a respondent is finding an injurious practice, it is the respondent's burden to prove that the disputed treatment, and this is important, from Mount Olive Poll, it says, offers a reasonable prospect of restoration or relief from the incapacity from which the workman is suffering. So here's what the appellate court says. Listen, you can't just say that you think that this course of treatment is better. You need to prove that in fact you can cure him of some incapacity, and in order to deny somebody benefits under injurious practice. So also, what we all know to be the ALAT standard, that once a claimant establishes that he's permanently and fully disabled by showing a diligent but unsuccessful job search, or that his age, training, experience, education, and conditions prevent him from obtaining an identifiable occupation in the state labor market, the burden of proof shifts. Sometimes it's said the burden of production. So the burden shifts to the respondent. Now the respondent must prove that there is an identifiable occupation and that a stable labor market exists. Well, they brought in no evidence of that whatsoever. They brought in no evidence that this proposes the injurious practice is preventing and turning back in the state of gainful employment. And then finally, and perhaps most importantly, the reason why the case topic got published is that now that when a claimant continues to follow up with his doctor, in this instance, 4 months after the surgery, the court held that this treatment is the type which ordinarily follows from a surgical procedure, or the sort which typically follows from emergency services, then a medical provider is not converted into a choice of disease.
Can I respond? I was the respondent. So we brought a motion for failure to cooperate with medical care, which is not injurious practices. There are actually two separate standards under Section 19D. One is you're proactively doing something to hurt yourself, and the second one is that you're not cooperating. The court basically looked at it and said, based on manifest weight of the evidence, we're putting more, we let the commission weigh the evidence. It was okay for them to believe Dr. Flores or Dr. Zulman. Our position always was that Dr. Zulman was more qualified, therefore more credible, therefore he was not cooperating with the appropriate medical care, not just some medical care from an intern. So they're two separate different causes. It's failure to cooperate and then the injurious practices, which is separate. The court made that clear. Those are two separate issues. Also, the appellate court was clear on saying that, they just felt as manifest weight they couldn't overturn the case because Dr. Flores was a doctor, whether or not he was qualified as Dr. Zulman, that was enough. And relative to the medical benefit portions of it, the court did talk about if it's just regular follow-up care after emergency visit, they felt it was reasonable. I will tell you, they cited, I think you cited a case from D.C. If that goes back up, they didn't, all the other cases in and around Illinois, Wisconsin, Michigan, I think Iowa, they all say no, that counts as a choice. So I'm not sure that will always be the way it is. I just couldn't do a petition for review.
All right, just real quick, on page 19, it says, the respondent has failed to prove that the testing/treatment that Dr. Zulman has prescribed offers a reasonable prospect of restoration or relief from the incapacity which Mr. Lamonti is suffering. Furthermore, respondent has failed to prove that Mr. Lamonti is doing things to retard his recovery. So if you're going to bring a motion under 19D, under either standard, it's your burden of proof to demonstrate that, in fact, you would restore to a state of restoring to a state of capacity from that incapacity. No, the RIC was just section 12 examination, and then criticism of other doctors who don't work with others.
So something that troubles me about the case is that in the opinion, is that after the respondent's motion to suspend benefits was denied, the respondent suspended benefits. So why did you bring the motion to suspend benefits? Did it end?
Well, no, because